This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we are now joined by the one and only Todd Lutsky from Cushing & Dolan, here to answer your estate planning questions live on the air. We got the phone lines open because, again, the segment's Ask Todd. It's your chance to ask your questions about your estate plan to Todd Lutsky. Studio line is at 888-205-2263. Get calling because we do see those spots fill up quickly. And we only have time to get through 2 or 3 questions in any particular show. That number is 888-205-2263. One more time, it is 888-205-2263. Mr. Lutsky, how are you doing today?
I am never better.
It's good.
How's that?
It's good.
Can you top that?
I can't. I'm actually in a little bit of a dour mood.
Dour?
Yeah.
Yeah.
Well, someone stole my journal, and then they died.
They stole your journal?
Yeah. Now my thoughts are with their family.
That's true.
So it's been tough. Todd, I want to talk a little bit about primary residences, and can you just kind of rattle off what are some of the different estate planning tools that someone can use to potentially protect a primary residence from creditors? What are the different options that are available?
So, and you know, that's important because I talk with clients a lot, and they always, they come to me sometimes and they say, oh, in fact, here, I had one the other day. They called up and they were wondering what to do, and they said, I've talked to 3 lawyers and nobody has said anything like you just said. So I'm like, okay, well, I don't know why. The problem I have with a comment like that is there oftentimes aren't that many options available. So when clients come to me and say they've heard this, and the other thing, I'm like, really? I'd like to know, because in order to protect assets from a nursing home, it's not like picking paint where you got a gazillion options. I would say that 2 ways to do it, if you're talking just about real estate for now: a trust. Just take your house, put it into an irrevocable Medicaid income-only trust. Remember, a revocable trust won't do it, so that's not an option, right? And once it's in there, in that kind of a trust, it can ultimately be protected. So that's an option. The other option is sometimes people use these things called life estates, where you take the property and put them into the hands of a child or children, plural, and retain the right to live there. That's a way of doing it. I think there's way more negatives with that approach than there are positives. But ultimately, the one positive is it will protect it from the nursing home in 5 years. So I guess that's an option for doing it. Other people come to me and they say, well, I heard I can just put my kid's name on the house and then we'll own it jointly. Well, that's not. Well, I guess it's an option, but to me, it's not really an option, because if I've given away half my house, that's not helpful for me as the mom and dads of the world, the parents who probably are your client. So you always want to do things that protect your client first, each other, husband, wife, if they're married, and ultimately it'll help the kids, but they're secondary. So things that might be options that don't provide protection for the parents first, I don't think are really options, but yet they're thrown out as options. So, give away your house. I've heard that. Well, yeah, I guess ultimately it'll protect it from the nursing home, but boy, there's nothing good that can come from that, but yet people think it's an option. So to me, I think, long-winded answer, Chuck, but at the end of the day, there's really not a lot of options. I think there's really only one, and that's setting up the trust and putting the house in. However, you could do a life estate with the remainder being the trust, but somehow the trust needs to be involved in the planning process.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. We still have room on the phone lines here at 888-205-2263. That is the number to call to ask Todd your estate planning questions live right now. Again, that number is 888-205-2263. We're going to take a quick break here, but when we come back, we're going to get right to your questions with Todd Lutsky. That number is 888-205-2263. One more time, it's 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
Still got a little bit of room on the phone line, so if you do have a question for Todd, 888-205-2263 is the number to call. Again, 888-205-2263. Let's go to Thomas in the car. Thomas, what is your question for Todd Lutsky?
Hey, Todd, do you have to own the house outright, or could you still be paying a mortgage and move it into the trust? You talked about.
So you're saying you've got a home. I'm just want to try to get to the facts. You have a home, and the home is currently encumbered?
Yeah, I can still pay a mortgage.
Is it your primary residence we're talking about, or a two-family or a rental primary residence?
It's not a two-family, but it's a primary residence.
Okay. So two points there. So a two-family primary residence, let's say renting one unit and living in the other, and we want to take that and put it into a trust, right? So if you want to put that into an irrevocable trust, not so much with a revocable trust, we don't have this concern. You can just transfer it right in. But if you wanted to put it into an irrevocable trust to get it protected ultimately from the cost of long-term care, we would actually put the property in, but you would reserve a life estate. So that's interesting. That's exactly what we're talking about in the guide, right? There's pros and cons to these life estates. I use them very rarely, but in your case would be one of the 3 times I would use a life estate is when you have a mortgage. Actually, 2 of the 3 times. When you have a mortgage, by reserving the life estate and putting the property in the trust, that nugget of ownership preserves the mortgage. So if you have a low interest rate mortgage and you're transferring the property to the trust in today's higher interest rates environment, the bank would look for any option possible to call the note. So this transfer could trigger the due on sale clause, but it will not once you reserve that life estate. So we don't have to tell the bank because we know it doesn't trigger the due on sale clause. So one, that preserves your mortgage. Secondly, if it's a rental and that's the only property, meaning it's a two-family, so you're renting it, and that's the only property we're putting in the trust, well, I might not want to have to file an income tax return for the trust. If the trust owned the whole property, it would have earned income, rental income. And then you'd have to file a tax return for the trust, although it would never pay any taxes. It would flow the income through to you, and you'd pick it up on your personal income tax return. So it's income tax neutral. Some people just don't like the bother of filing that extra tax return. So instead of that, you could reserve this life estate, which you'd be doing anyway because it's of the mortgage. But by reserving that life estate, not only does it give you the right to live there and preserve the mortgage, it also gives you the right to the income. So now the rental checks can continue to be written directly to you as they were in the past. You will collect the rent, deposit it in your personal bank account, and move on, and you will not have to file any income tax returns for the trust. So long-winded answer, but I think it's the right one, and it gives you all the options you need. So if I was you, get your planning done, use that trust. It'll work. Folks, this is a great question because it ties into the guide, right? The life estates, we're trying to help you understand the consequences of a life estate. So if you've got one, learn what you've done, get the guide. If you haven't done one and you're thinking about doing one, please get the guide so you can learn what you're getting into. What I mean by that is there's gift tax consequences. There's income tax consequences. There's control issues. What if I want to sell? What if I want to downsize? Where's the money go if it's in a life estate arrangement? What are the income tax implications of that arrangement if I want to do any of these things? Folks, get the guide, understand how they work, and sometimes the short answer isn't always the better answer. The short version of doing planning, that is. 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Todd, I got another one queued up for you here. Let's go to John in Weymouth. John, what's your question for Todd Lutsky?
Yes, hi, Todd. Hi. Todd, I just recently sold my house, and I gave everything to my ex-wife for $1, and now what I have left is roughly $1 million in my IRA, and I want to protect it from a nursing home. Is there any way I can protect these monies, and am I going to get in trouble for selling the house to my ex-wife for $1?
So let's try to figure. First of all, how old are you, John?
77.
So you're 77. Do you have any children?
Yes. Mm-hmm.
Okay. So here's the concern. You have $1 million in an IRA. When you say you sold the house to your wife for your ex-wife, for $1. So the divorce is final, right? When you say ex-wife, it's actually a final divorce.
Yes. Mm-hmm.
Okay. And the selling it to your ex-wife for $1, was that part of the divorce settlement, or is that something that happened after the fact?
We had an amicable divorce, and I just said, you keep the house, and where my monies were all in IRA, I said, we'll go that way. You go your way, and I'll go mine.
I see. So you kind of gave her the house in exchange for your ability to keep your IRA.
Yeah.
Okay. So basically it was a gift from you to your wife, because if you say you sold it for $1, that's not really a sale. I hear people say that all the time. The government would just treat that as a gift. Okay. Now, if in fact it was related to the divorce, so if it's tied to the divorce, I'm guessing that you could make the argument that you made this gift incident to the divorce, and that you were hopefully still technically married when you made the gift. Reason being, that would qualify for the marital deduction, meaning you can gift as much as you want to a spouse, and there's no gift tax involved. If in fact you were divorced, then you made a taxable gift to your spouse. So how much was the house worth?
$500,000.
Okay, so you technically, if you weren't married at the time and you were officially divorced, you made a taxable gift of $500,000. Is that going to come back and bite you? Maybe not. I mean, you have the ability to shelter $13.9 million for gift tax purposes, so clearly it's under that. You'd need to file a gift tax return, but you wouldn't have any gift tax due. But it would eat into your Massachusetts exemption as well. So good news is, if your total Massachusetts exemption or if your total Massachusetts estate is only $1 million, then you're under the $2 million Massachusetts exemption. Even if you reduce the mass exemption by $500,000, which you would have to do for the taxable gift that you made to your ex-wife, you're still under $1.5 million. So wipe your brow, and we have no gift tax and no estate tax. Problem is, I still haven't answered your question about the IRA, which is, can I protect the IRA from the nursing home? And I don't really see a way to do that. And here's why. If you wanted to move the IRA money to one of these irrevocable trusts, you really can't, because if you do, you got to take it out, pay income tax on it, and then put the balance in. So even if I took out $500,000 thinking I'd leave $500 in my IRA, you're looking at close to $200,000 in tax. You figure 40% federal and state on $500,000. So I don't think that's a great idea. So unfortunately, the type of asset that you retained, great for you, live on it, please enjoy it, but not real easy to protect from from the nursing home. And then, of course, you just set up designated beneficiaries on that IRA to make sure it goes to whoever you want it to go to and how and when they get it, which could be a trust.
Mr. Lutsky, I appreciate you taking the time to join us today.
It's always my pleasure. Thank you.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.